Trump is losing it tonight, and there's a very real reason why. A federal judge just ordered prosecutors to preserve every piece of grand jury evidence tied to Trump and his inner circle. Not summaries, not select documents, everything. Thousands of pages of transcripts, emails, witness statements, private strategy notes. The real story behind the cover-ups, the pressure campaigns, the secret conversations. And Trump's legal team is in full meltdown mode because once this evidence is locked, it can't be destroyed, hidden, or spun. This is the moment the secrecy collapses. The truth is coming, and Trump knows it. Watch this.
Thanks to you at home for joining us this hour as well. Happy Friday. Happy to have you here. Well, this sort of changes everything. One of the increasingly awkward dynamics in the impeachment proceedings against President Trump is that even the president's most ardent supporters, by and large, they have already given up arguing that the president's behavior was okay. And that is perhaps inevitable given this impeachment for this conduct. I mean, it is hard to argue that it is, coolio with the Constitution or with the American people or even just with Republicans for a president to solicit help from a foreign government in the form of stuff he can use against his domestic political opponents. I mean, the president's supporters in the White House tried for a while to argue that it was okay that he asked for that stuff from a foreign government because he was asking for it for free. There was no quid pro quo. They tried that for a while. It was kind of a besides the point argument because it doesn't matter if you agree to trade for information.
Tonight isn't about palace intrigue or who won the day on cable. It's about whether facts can still beat noise in the United States of America. A federal judge just did something simple and profoundly important. Told prosecutors to preserve the grand jury record, transcripts, exhibits, communications, the whole paper trail. That's not a headline to scroll past. That's the backbone of accountability asserting itself in real time. Because if you can't protect the record, you can't protect the truth. And if you can't protect the truth, you can't protect a democracy. Let me start plain. The country has been asked again and again to accept a politics where everything is negotiable. Norms, laws, even basic reality. We've been told to shrug at missing documents, to accept alternate facts, to believe that loyalty to a single man equals patriotism. No, the rule of law is not a mood. It is a process. And this order is the process putting up a bright red stop sign. No shredders, no back channels, no oops, it vanished. Lock the evidence down so the truth can breathe. Why does that matter to ordinary citizens who aren't lawyers and don't live on a packed talking points? Because when any one of us faces the system, whether it's a traffic ticket or a housing dispute, the evidence gets preserved. It's routine. It's non-negotiable. That's how you get fairness. You don't get to say, sorry, the emails were deleted, or those files were just souvenirs. If the powerful can wiggle out of that basic expectation, then the law becomes a costume. The strong man wears it when it flatters him and tosses it when it constrains him. Here's the through line I want to stitch through everything tonight. This is a contest between transparency and impunity, between a system that protects the record and a movement that survives by fogging it. When a judge orders grand jury materials preserved, fully, immediately, it puts oxygen into the process. It tells everyone in the chain, from the intern to the senior counsel, what you did, what you said, where you sent it, keep it. Don't you dare make it disappear. That's how we go from rumors to receipts.
Off the hook, cross-eyed letter to the House of Representatives. And then they released it publicly because they wanted to make clear that they intended this letter to be their final word on the subject. Based on this letter, nobody from any point of the administration should participate in the fake impeachment because the fake impeachment is fake. And the immediate reaction of the legal world to this letter was like, whoa, you sure that was written by a lawyer? It was just greeted with widespread ridicule. It wasn't a particularly legal or even legal-ish argument. But that is being put forward as the official position of the White House.
Now let's talk mechanics for a second. because I think we underappreciate the power of paperwork. People imagine corruption as a single cinematic moment, a secret envelope, a hushed conversation. Real life is messier and more bureaucratic. It's text threads, calendar invites, drafts with track changes. It's a stray sentence that suddenly explains a month of spin. Paper doesn't shout, it doesn't post, it doesn't care who's trending, but when a court secures it, the story it tells becomes very hard to bulldoze. And look, grand juries are secret for good reasons. You don't want reputations destroyed by leaks when charges may never be filed. You don't want witnesses looking over their shoulders. I respect that. But secrecy is not supposed to be a blanket that smothers accountability. It's a temporary veil to keep the process clean. What breaks the system is not responsible preservation with an eye to future disclosure. What breaks the system is letting powerful people hide behind process to bury inconvenient facts. There's a difference, and the judge landed on the right side of it.
About how the impeachment committees have been taking depositions from witnesses, even what room they've been doing it in. The room is the problem. I mean, this cockamamie argument and why it is not okay for Democratic-led committees to use closed-door depositions with witnesses, but it is okay for Republicans to have done that. I mean, it's just been kind of weak, and I think that's why it's been kind of a circus. There usually is an inverse ratio between the volume at which an argument is made and the quality of its logic.
Why is the Trump orbit rattled? Because control of the narrative has been the first and last line of defense for years. When the facts are blurry, the megaphone wins. When the paper is secured, the megaphone shrinks. If those records show hands-on direction about sensitive documents, what to keep, where to move them, how to frame the public story, that punctures the I didn't know defense. If those records capture conversations that fall under the crime-fraud exception, privilege doesn't shield them. If those records reveal witnesses the defense didn't anticipate, career officials, aides, even lawyers pressured to fix things, the chessboard changes overnight. And there's a broader civic point here. We have been conditioned to think of accountability as inherently partisan. It is not. It is constitutional. The law, at its best, makes the powerful live by the same rules as the rest of us. The rhetoric that says any scrutiny of a strong man is a witch hunt is a tell, because people who are confident in the facts don't fear the transcript. They don't fear the receipts. They don't sprint for the shredder. They sprint for the light. Let me bring this down to the ground level of how power works. Authoritarian movements don't succeed because they convince everyone. They succeed because they exhaust enough people into silence and then control a narrow set of institutions: information, enforcement, and impunity. Information, what you're allowed to know. Enforcement, who gets punished and who gets a pass. Impunity, the belief inside the inner circle that the rules don't apply. A preservation order is a direct strike at the third pillar. It says even inside the circle, there are rules. Even behind closed doors, there will be a record. And when there's a record, other things become possible. Witnesses who were wavering gain confidence. Prosecutors can map patterns instead of chasing rumors. Judges can adjudicate based on evidence, not press conferences. And maybe most importantly, future would-be strongmen see a cost to treating the state like a trophy case. Deterrence isn't just about prison terms. It's about visible lines that, when crossed, trigger real consequences. Now, I know some people will say, isn't this unusual? Yes, and that's the point. The stakes here are unusual. We're not talking about a routine document dispute in a sleepy agency. We're talking about a sustained attempt to turn public power into private privilege, and a years-long effort to flood the zone with nonsense so the public can't tell what's real. In that context, a judge insisting on preservation is not radical. It is the minimum required to restore balance. I want to speak to conservatives of good faith for a moment. You don't have to love my politics to see the value here. If a Democrat were accused of treating classified records like personal trophies, you would want the evidence preserved. You would want the transcripts protected. You would want the same rules that apply to a contractor in Tulsa to apply to a cabinet official in Washington. That's not liberal, that's American. And if your leaders tell you that protecting the record is partisan, ask them why they're allergic to sunlight. Let's also acknowledge the human dimension. People, real people, took risks to tell the truth. Civil servants who said no when it was easier and safer to nod along. Archivists who insisted that public records are not personal souvenirs. Lawyers who refused to launder pressure into legalese. Every time the record is preserved, we honor that courage. We promise them, your truth won't be buried by someone else's tantrum. There's another cost here that isn't flashy but matters deeply. Time. The favorite tactic of bad faith actors is delay. Drag it out. Appeal everything. Wait for the circus to move on. Preservation kneecaps that play. You can appeal a ruling. You can't appeal a missing file back into existence. Once the evidence is secured, time works in favor of the truth for a change. The slow churn of document review, cross-referencing, and corroboration, none of that is cable ready. But it is justice ready, and that's what counts. Now, does preservation declare guilt? No. It declares seriousness. It says the court is willing to draw a hard boundary to protect the process. And that matters even if some of the secured material never becomes public, even if some claims never ripen into charges, because the signal to the system is unmistakable. The rules still apply, not to them, to everyone. I also want to talk about precedent. People hear that word and their eyes glaze over. Don't. Precedent is the story we tell ourselves about what's normal. And normal is contagious. If courts normalize the idea that grand jury records in high-stakes political cases must be robustly preserved and, when appropriate, responsibly disclosed, we shift the incentives across the board. Future officials will have fewer places to hide. Future lawyers will think twice before laundering this conduct into strategy. Future staffers will know the receipts don't evaporate when the boss gets mad. That's not fishing. That's fairness. What about the fear that more sunlight means more spectacle, more out-of-context clips? It's a real concern, but secrecy isn't the antidote to bad faith. Context is. Preservation enables context. It gives judges the full picture to decide what can responsibly be shared and what must remain sealed. It gives the public a chance to see evidence-backed narratives rather than edible for 24 hours outrage. And frankly, the people who scream witch hunt, the loudest, have never been shy about weaponizing partial information. The answer to that is more truth, not less. Let's address the political reality. Some Republican leaders are going to look at this and see a growing risk, not only to Trump, but to anyone who tethered their brand to his impunity. Each step toward evidence and away from vibes creates a choice. Stay lashed to the mast or climb down and say, the law is the law. I won't pretend that's easy. The incentives inside the party are brutal, but history is watching, and so are voters who are exhausted by chaos and hungry for decency. There's a civic invitation here too. We, you and me, have to decide what kind of country we're going to be in the boring moments, not just the dramatic ones. Preservation orders are boring on purpose. They are the quiet work of adults safeguarding the frame so the painting can be judged. If we only show up for the shouting and not the safeguarding, we will lose the republic in the procedural margins. Don't do that. Pay attention to the boring. It's where the future hides. I'd keep coming back to a simple moral test. If the evidence helps you, you welcome it. If the evidence hurts you, you still welcome it, because the truth is more important than your pride. That's patriotism as a practice, not a slogan. The flag doesn't mean anything if it can't restrain the people who wave it the hardest. The Constitution is just parchment if it can't bind the office holders who claim to love it most. And to those saying, this will never change minds, I'll offer this. Institutions don't always move hearts first. They move thresholds. They change what power can get away with. They raise the floor of accountability. People notice when the game stops feeling rigged. They notice when judges act like judges, not partisans. They notice when the paper trail speaks louder than the podium. That noticing is the beginning of trust, and trust is the oxygen of a democracy. Let's talk about deterrence again, because it's vital. Somewhere in some future administration, a senior official is going to consider cutting a corner and telling staff to make it disappear. The memory of this moment, of a court freezing the record, of prosecutors securing the receipts, can whisper into that room, "Don't. It won't vanish. You will get caught." That whisper saves us grief we'll never see. That's the hidden dividend of doing the right thing now. I know this has been abstract, so let me crystallize it into 3 takeaways. First, preservation is not punishment, it's protection. Protection for the truth, protection for due process, protection for the public's right to know when the time is right. Second, resistance to preservation is a red flag. If your defense strategy needs records to go missing, you don't have a defense. You have a problem. Third, the rule of law is a habit, not an event. Today's order is a rep of that habit. We need more reps. And here's the part I can't shake. Our system held after 2020 because enough people inside it decided to tell the truth. Not perfectly, not cleanly, but enough. What we owe them now is a process that doesn't let their truth evaporate in a haze of PR and threats. We owe them guardianship of the record. That's what this judge just provided. Not a verdict, a vow. The paper will be there when the gavel falls. So where does this go? The answer is both sobering and hopeful. Sobering, because securing the record is the beginning, not the end. There will be more motions, more noise, more efforts to confuse and delay. Hopeful, because once the evidence is chained to the floor, time becomes an ally of accountability. Patterns emerge. Contradictions harden into conclusions. What looked like a fog becomes a map. When the fog lifts, and it will, don't expect fireworks, expect footnotes, expect timelines, expect dull-sounding exhibits that together tell a story no rally can erase. That is how democracies defend themselves, not with drama, but with documentation, not with vengeance, but with verification. If that sounds unglamorous, good. Glamour is how we got into this mess. Bravity is how we get out. Let me finish where we began. The core conflict is transparency versus impunity. Tonight, transparency won a round, not because the judge hates a defendant or sides with a party, but because the court sided with the republic's need for a trustworthy record. That's what grown-up countries do when power tests their limits. They do the boring, crucial, patriotic thing. Preserve the evidence. Follow the facts. Accept what they show, even when it cuts against your team. That is the job. That is the oath. And that is how a free people keep their freedom, by insisting that truth, not noise, gets the final word.